Good morning. Welcome to the Friday Grief Chat. It is nice to see everybody here. We've got Facebook saying we've got errors. Okay, good enough. It is Friday. Let's try this again. I'm Jill. I'm here with Maureen Lyons, who is an estate planning attorney and does all the things. Deb just popped in, and it is that kind of Friday. First, I do want to put out a word to all my friends on the East Coast, those who are dealing with the emotional and all the other impacts of the Francis Scott Key Bridge. You are definitely in the thoughts of everybody around the station. We know that that's a big loss for you, both in terms of the people and the lives lost and the image lost of who your city is and all of the things it's going to do to all of your lives in upending your world for a while. So you are in the thoughts of everybody here. I know I can say that with confidence. Deb, welcome. Meet Maureen.
Hi, Maureen. Good
Hi,
you're
Deb.
here. A lot
So-
of my clients are dealing with the interactions of family members after that person dies, and they have to deal with the estate. Excuse me.
You sound awful today. So we'll let Deb cough. Yes, she's been sick for about 2 weeks now.
Oh, no.
Yeah. Maureen, tell us about, first of all, what made you want to do estate law? What drew you to that?
I'm one of those people who, I'm the youngest of five. And so I was always kind of raised by my parents to, what are you going to be when you grow up? Dad was a doctor, and I have a lot of physicians in my family, and I liked science, but I didn't really want to be a physician. So I early on developed an interest in law, not really sure what kind of law when I was younger, though. But it really kind of, when my mom was sick she had breast cancer diagnosed when I was in third or fourth grade, and passed away when I was 18. And after she passed away, my dad got to experience dealing with the court and probating her estate, and that kind of cemented in his mind that that no one should really want to opt for having to deal with courts and all that if there was a better way. So he personally learned about the pros and cons, and he said, I see both the need, and he just thought it would be a good match for my type of personality, to look into estate planning law, because I don't want to be in the courthouse. I like meeting with people in my office or in their homes sometimes, or where have you, and I like to be a little more proactive if possible,
And not be the one who's having to fight things out all the darn time.
Exactly.
Yeah, that makes perfect sense. And as the youngest, you probably had some caregiver sense too.
Well, yeah.
Some, yeah. We have a lot of people on. Deb, you've got background noise. We have a lot of people who come to our site, and they are. I am getting ready for a loss. I have a loved one with dementia. They show up here because Jill does dementia. And Deb is a nurse. They want to know, how do I make it easier? What do I need to do so I don't end up tearing my hair out? What do I do proactively? And how do I do it without upsetting someone? If I have to go tell mom she needs to get her estate planned, the message to mom is, I want you dead, which is, of course, not what you're saying, but it's an issue, right?
Exactly. Is it still a lot of background noise, Jill?
Yeah, lots of buzzing. Lots of buzzing.
I don't have any. How's that?
Still loud, like there's a hairdryer or something.
I don't have any. That's weird.
Your microphone.
I'll just
mute.
Yeah.
Pop in.
I'll mute myself until I have a question.
Okay.
Sounds good.
Maureen, how do we help those folks?
That's always a pretty delicate balance to try to achieve, because not that every parent thinks, hey, you want me dead, but what you hear is, it's not going to make me live any longer. I mean, I've gone, for the older folks, I've gone 80 years without doing anything. What makes you think I have to do something now? And there's a sense that you're giving something up. even, and to an extent you are, when you're saying, hey, maybe somebody needs to take over managing my finances, making healthcare decisions, but it's kind of the last way to retain control, to have your say so. In the event the time comes when you can't speak for yourself, and then, clearly that occurs after you pass away. But really, the greater focus is protecting yourself as well as possible while you're still alive. And the lawyer I had been working with, Terry Moynihan, just passed away a couple months ago, but he used the phrase lurching from crisis to crisis, which I found so evocative that I stole that from him years ago and mention it almost every time I talk to somebody. Isn't there a better way to, so that you just don't have that impending sense of dread because you don't know that there's anything you can do. And so it starts with education, with the what can you do? And like, as with many things, the earlier you address it, the more options you have.
Absolutely. One of the things we're seeing more and more of, and that's partly because Deb and I run around in griefland and end of life land, that's what we inhabit, is an increasing use of end of life doulas or death doulas, and doing an actual end of life plan. Is that something that they could discuss with an estate planning attorney to have included in any kind of trust they might write?
Well, for example, when I work with my clients, I don't do one-off documents. So the answer is absolutely yes. I'm going to be consulting with them and preparing a comprehensive plan that deals with the death planning, the health, the during your life, the financial, the healthcare. If it's a married couple, what happens if only one of us is incapacitated? What happens if both of us are? And while there's certain aspects of the plan that I wouldn't be preparing, we certainly want things coordinated so that there is no incompatibility. And I'm happier than a clam to work with trusted advisors to make sure that everybody understands how the plan is hopefully going to work.
Gotcha. I've got somebody texting saying, what happens if a spouse receives inheritance per stirps? I don't even know what stirps is.
That's a Latin phrase, per stirpes.
Okay.
And that term refers to how members of for example, if children were inheriting from a parent and it says per stirpes, then it's how the distribution would go, divided by the number of people that in that generation inheriting.
Okay, so that's like a division process.
It is, yes.
Okay. So if a spouse that receives an inheritance,
may I bring up the more interesting?
Yes,
part?
Please. I'm trying to understand this question while you're, please.
Because that's a pretty particular, question that talks about the division, but it's important for anyone who's receiving an inheritance to understand that is that person's separate property, unless and until, and I should say I am a California attorney, and my experience and my advice can only be, is only California specific, but it does in California. So that's inheritors' separate property unless and until they do something to transmute it, which is the term that you can convert it to community property, but that takes something, some proactive action, although it can be, even if the intent isn't there, putting that inheritance into the joint bank account, because that's where you have an account. You can undo it, but it's best off to be really clean if you're intending to keep it as your own property with full control over that.
So you have to make sure that if you're getting an inheritance, and you don't want that to go to your spouse per se, you want to leave it aside for the kids or something directly. We have a lot of folks with second and third marriages.
That's right.
Right. Here's Jill on number 3. So not because of any fling I planned, by the way, then you put it separately and keep it separately. So the question that came up for the per stirpes is, what happens if the spouse inherits per stirpes and then that spouse dies before the estate is distributed?
If they have passed away before the estate has been distributed, however, they have survived, whoever's death, whoever
The estate
died,
came from, yeah.
then that spouse would have been vested in their interest, and so should that
They should then inherit.
It should go down that line. There can be language in the document that could counteract that, but it's the key usually is whether or not when the person becomes vested in whatever interest they would be.
Okay, thank you for that. That's helping someone who's got someone at home who is very ill and just had multiple losses and is trying to make sense of the world. So lots to make sense of.
I don't want to go down an area that isn't of general interest, but one other thing I'll point out about separate versus community property in the state of California is for people who don't do any planning, there can be kind of an odd surprise after the person has passed away to learn that no, it's not going to be my spouse and my two kids are going to share 50-50 in this inheritance because I didn't do anything. For example, let's say there's $90,000 that you kept in a separate account and never did any planning, and you have a spouse and two kids. That spouse is only going to be entitled to a third of that, and then the kids would share 2/3. But even and if there were 4 kids, they'd still get 2/3. So the math isn't always what people expect. Often it doesn't matter, but it's just you can't always logic your way through how things.
You just want to make sure you've got it written down.
Well,
right?
I'm certainly yeah. I mean, like everything, it almost depends on how much control you care about.
Mm-hmm. Tell us about what's involved in if there was a trust. What kind of documents can someone put in a trust to take care of themselves as pre-planning, so while they are at end of life and then for their estate afterward?
Well, here's how I like to address this is most people are more familiar with the will because of either movies or TVs. You may have been exposed to somebody passes away and there's this dramatic reading of a document called the will,
right? And
it always seems to be pretty dramatic, and that's always a and so that's a singular document that really deals with what happens to my stuff when I'm gone. What's become more popular, and it works fine, it's just going to guarantee that somebody's going to have to go to court to open a proceeding called a probate to handle wrapping up the affairs of the person who died. In California and certain other jurisdictions, the use of a trust has become a popular way to engage in planning so that you can avoid anyone having to go to court if you handle things properly. If the will was like one chapter of your guidebook for life, the trust would be a multi-chapter book that deals with, with death, incapacity. If it's 2 spouses, what if one's alive and one's dead? It can address kind of the multitude of issues that arise, and yet ultimately still deal with the who gets what when I'm gone. Regardless of whether you choose the trust or the will as the centerpiece of your plan, it's really critically important to get those powers of attorney in place. And so there, the powers of attorney are those documents that it can deal with your financial matters or healthcare decision making. They're separate documents, although you might have the same people that you want to appoint as your decision makers. In the event that you can't handle things on your own behalf. I mean, there are also flavors of powers of attorney, but I don't want to. I guess I don't want to give a lecture so much as be.
So you have the durable power of attorney for healthcare,
and I'll tell you, to do with healthcare. Lawyers love to use different terms or different ways of getting to the same end. So power of attorney for healthcare in California, often people rely on a singular document called the Advanced Healthcare Directive that addresses not just who your decision makers are, if you can't speak for yourself. It will also, in that same document, deal with your end of life preferences, whether that's being kept alive by all means, or no extraordinary measures, or or what have you. And then that even incorporates some HIPAA authorizations to make it clear that you want your confidential healthcare information shared with the people named therein. I actually like to deal with separate documents that kind of cover the same thing, but so they're just different ways of achieving the same end. For financial matters, that could be, if anyone's a caregiver right now or dealt with trying to get somebody's bills paid when their name isn't on the account, you can be as well-meaning as possible, but but the bank's stuck if they have no reason to see that you have any legal authority to write this check for mom or do some things. So if it's important, if it's not a trust account, that you at least make sure somebody has a power of attorney so that they could handle things like bill paying for somebody who's become incapacitated.
Or put someone on the bank account with you.
Don't.
Well, I mean, when you're putting them on, I mean, people do it can be very functional, but you're giving them a gift. So
yes, you are.
If you have named them as a joint tenant, better never be a falling out or a lawsuit or something that happens where all of a sudden that money that you thought was your nest egg or paying your month-to-month bills all of a sudden could be used for those other purposes. So that's why often people will put somebody's name on an account either because the balance is such that they're comfortable with with that being a gift, and and they just figure, okay, that's quick, easy access, and so it can be part of the plan, but it's kind of a do-it-yourself option that I would not put top of the list.
Okay, so a power of attorney that the bank would accept. Deb, question?
So Gail McMillan wants to know if Maureen is available for new clients.
And I can set her up. Gail, if you were in California, absolutely, I'm taking on new clients. And I will make sure that Jill and Deb have my contact information, so you can jump on my website and schedule a no-cost consult, and we can discuss things in further detail.
Excellent. Thank you. There was another question. Somebody says, if there's a trust, does everybody in the trust find out what everybody else in the trust is receiving after a death? Does everyone have to be notified of percentages?
That's a good question. And the answer is really yes. We overemphasize the benefit of no one having to go to court when we're talking about the benefits of a trust, that we don't necessarily talk about the fact that there's still proper trust administration procedures that need to be followed. And among those are providing legal notice to any beneficiary named or anyone who would be a natural heir if the person hadn't done any planning. The person has passed away, and at least that, and let them know that they have a right to request a copy of the trust, and they're legally entitled. 9 out of 10, when I handle a trust administration, I just tell my clients, let's just get it out there now and find out if there's going to be any challenges. I mean, you can't, if you're just trying to get things to move along, that's the best way of handling it, in my opinion. But you can't refuse to share that information.
Okay. That thing about notifying, my mom left a will, and I am finishing probate in the next 2 months. I hope and pray. And I got to say, her attorney didn't even give her the signed copy. He put on there that he was keeping the signed copy in his office, and then he went and died.
That used to happen. Yeah.
Oh my God. And so they dumped all of the probate all of their wills that they'd ever done in that practice in the basement of probate court. That was fun. But in the meantime, when I went in, they were like, yeah, you have to notify everyone. You have to tell us of every person by your mom's name who died in the last year. Her name was Margaret Johnson. You seriously want to know every Margaret Johnson who died in the entire United States in the last year? Because, yeah. So the judge went, why don't we do the last 60 days?
Oh, yeah, I'm not sure what that was about, but.
They wanted to know, they wanted the obituaries to show that there was nobody else who should be inheriting, even though the will was just the three of us. that kind of thing. And I did the tree and all that, but she wanted to see obituaries. And so I provided 60 pages of obituaries.
Wow. Yeah, that's a little different. I try not to do probates anymore, but I have one that's kind of an offshoot of the administration I handled. And the gentleman who passed away was an adopted only child who passed away in his 80s. It was a fairly prolific family of at his parents' level though, and I had to do this tremendous air search just to figure out who is entitled to notice. And given his age, now we're talking subsequent generations, and it's quite the challenge, and it's expensive.
It is. I'm doing mine, but it's simple. It's just 3. Yeah, Deb.
It still disheartens me about a friend of mine. I happen to be on his at the hospital point of contact, like in case of an emergency. But he never had a will, same age as I, 67, and he died in his sleep suddenly. Not ill, just suddenly. So all of his savings, all of his possessions or whatever, all goes to the state. And it just, I'm just sort of sick about that. I mean, I would have liked one thing to remember my friend by, but and I had told him, he knows what I do. I said, please get a will. And he never did, or anything.
Deb, it's unlikely that the anything's going to go to the state per se, but it just gets tied up until the next of kin, and the next of kin could be some distant whatever.
He doesn't have anybody,
or it ends up in unclaimed property. Well, he doesn't, but I mean, he had a parent who had So maybe it'll stay in unclaimed property for a long time.
They usually put an ad sometime in the paper.
That's right. A probate, you have to publish notice.
Yeah, that's it. Yeah. Mm-hmm. So it just makes me sad.
I'm sorry to hear that. Yeah, that's.
Yeah.
Maureen, how do you approach someone who's coming in who is sort of reluctant to want to? I mean, they know they need to do this, but how do you help them see how to ferret out what needs to be done? What they want, a power of attorney, they want HIPAA, they want a trust. How do you help them address this is really happening? And there's only, what we say is there's only one way out of this life. We are all going to die, and we need to plan for it. How do you help get people from A to C?
Well, it's interesting. I hear those words, and just like me trying to go to a doctor and say, I need this test. Yeah, right. Where did I go to school? So my first conversation is to make sure that it's somebody who's trying to deal with protecting themselves while they're alive, or plan, for what happens after I'm up. Making sure they want somebody who does the kind of work I do. And then I, instead of talking about the specific documents at that point, we talk about them, and I kind of like to introduce it with, who do you love? Hopefully yourself, that you want to protect yourself. And then, if it's a couple, there's that dynamic. If you have children, if you don't have children, so who are you trying to plan and protect, plan for and protect, and then what do you have? And that turns out to be the more useful conversation than having them think, okay, I would like a trust-based estate plan that has a special needs trust. We'll get there, but they don't have to know that. They just have to tell me a little bit about themselves and who they are and what they have. And while the language can sound the same, do you have a trust? Do you have this? It's kind of like either the contents can be so very different depending on a person's situation. Person may have a trust who has one asset in that trust that is their house, but that's their for most people, it's their most valuable asset, and they've got pretty serious ideas about how they want that to be distributed or handled after they're gone. Other people might have many assets and many beneficiaries, and so it's kind of what you fill it up with. and it's not a homework assignment. You know, some people think they have to do so much research before they can talk to me about what they want to do, and you know, that's my job.
You need to sit down with them and tell them what needs to be researched.
Well, they contact me and then if we take it further, I send them my worksheet, which again is, you know, tell me about you, tell me about what you have, tell me what your goals are, and then we meet, and then I'm not just sitting there collecting information at that time. We can have a more meaningful conversation about their concerns, and you know, and the more personal things. A lot of people just assume, for example, when they're considering who do I want to make decisions for me. Well, you know, I've got 3 kids, so I guess the oldest would be my first choice. That could be perfect, but you know, the oldest maybe is not the best money manager, or doesn't agree with you about how you want to live your life. And you know, and so somebody may be better suited, and it may not be a child. I mean, you know, so those are conversations I want to have with people. And it's a little easier to have the conversation in families where, when we get to healthcare, there's somebody who's in the healthcare community. It's like, well, do you really think Johnny, who's the investment banker, is your best choice when you've got, you know, his sister who's been in medicine for for her entire career, and you know, evaluating things like, well, who, you know, boots on the ground, is there somebody who just physically is going to really have, you know, potentially have, you know, that sort of insight that's of value to you, or is that, you know, similarly, maybe that's not as important because there's somebody who you really trust more with decisions, and you know, they can hire the caregiver, and they can hire the financial person, and they can coordinate, and they can travel. So again, at least we can explore the options, and maybe it's as simple as when you came in, you know, yeah, you're absolutely right. That's, you know, that's the way that makes most sense, but maybe
I want to say, because more and more I am seeing estrangement in families, and I want to give people permission. I'm saying, if you don't think your kids are suited for, or they haven't talked to you for X number of years or something, do look outside of the bio family to make sure that somebody that you trust can do either one, the medical or power of attorney. Because people say, well, it's my kid, they should do it. Not necessarily. I just wanted to say I agree with you. Somebody has to. And if your kids aren't talking to you, don't assume that they want to do this because you're the parent.
And it's not just an honor. I mean, it's a job with responsibility.
Mm-hmm.
And again, if you don't care, you don't have to do any of that. But just understand, when things go really haywire, or when that Alzheimer's has gotten so advanced that you can't handle things safely, then somebody's going to go to court to petition to become your conservator, and you've lost all chance to have any input. And you know, it's appropriate that we have those options. You know, you have to have somebody who could be put into place in those situations. But I think by and large, most of us know the conservatorships aren't an ideal, when you know planning can avoid that.
And I also say this because I have seen this happen, where the spouse, who is the step parent, their biological father died. The spouse contests everything that's in the will that the spouse upon his death wanted to go stuff to his children, but the step parent said, no, it's all mine. And then you just can do the best you can with plans for the future. I mean, I recommend you just haunt them afterwards. But
that would be really good, though. I mean, for example, with blended families, that's a good example. You know, it's very common that the couple still owns things jointly. So they create a joint trust. But you can provide that I can provide that if I die first, my share of the community property and my separate property can be allocated to a subtrust that becomes irrevocable. And I'm fine. My spouse can benefit from the income that generates. I'm not trying to penalize my spouse, but I am trying to protect my kids or my beneficiaries. And so there are a lot of things you can bring to the table, and as long as I know that that's a concern, yeah, we can build that into your plan.
Yeah.
That's good to know. And that is the question that just came through. So, yeah, thank you for that. I appreciate that. So if someone is looking at what do they need to do, they need to call someone like Maureen in whatever state they're in, and they need to let them guide them through the process. I need to know about you. This may seem invasive, but it's invasive for a reason, because I need to know what you need to plan for. I need to know who you need to plan for. And if we get the planning done now, it means we don't have problems later. Right?
I'm on board with that. I'll tell you, in my presentations and talks, I usually end with a quote from tennis player Arthur Ashe, who I greatly admired. And his quote is, "Start where you are, use what you have, and do what you can." Estate planning, for some people, the cost can be prohibitive to come work with me or someone else. But powers of attorney, there's a danger here. But I mean, there are form powers of attorney, and more of you are probably familiar with the fact that you can usually get an advanced healthcare directive from a provider. And so there are things you can at least start putting together. And, I'm not going to equate that with a well-designed plan, created in consultation with your attorney, but, it might be it might be a really good start. So it doesn't, and so often people say, "Oh, I don't have enough to plan for. I don't have." Well, do you care who's making these decisions for you?
Your body needs to be cared for before and after.
Frankly, once anyone's an adult, they, not that I know that 18-year-olds aren't rushing out to create powers of attorney, but mom and dad sometimes learn that really terrible lesson that, oh, we don't have the same authority we had just last year.
That's exactly right. And people who think that there's common law marriage, which is something I saw all the time in hospice and I see in grief, but we lived together for 20 years. That doesn't count.
Not in California, no.
Their parents get to decide how they're buried because you are not related to them, which is a tough thing to find out.
Mm-hmm.
Yeah.
Illinois is the same.
So where does one keep one's trust, Maureen? Last question. Where do we put it so that when the time comes, I can't tell you how many times with hospice and doing work with folks ahead of a death, they don't even know where the ashes are of the late spouse because dad usually gets put in the garage somewhere near the tool chest. Where do we put the trust so it can be found at that moment?
Sometimes that decision is contingent on how much you want to share during your lifetime, or with whoever you're entrusting. You may just want to give your trustee, information that you can find it on the third shelf of my bookcase in the in the study. Some people say, well, I want to lock mine up and just make sure that it's very well protected. And the problem is people tend to treat everything as this one whole, and you find out that crisis happens and no one can get to the healthcare, it's particularly like the healthcare directives. I want distributed freely. Every doctor should have a copy of your healthcare information decision. If you're going into the hospital, bring a copy with you. Photocopies are as valid as the originals. So, make sure you have that. The trust, of course, people have some more privacy concerns with that, particularly because they may change it over time and they think, well, geez, I don't want to feel like I'm locked into this. So
I mean, if you're going to lock it up in a safe, just make sure you've been pretty clear, who's going to have access to the safe, and, and know what the risks
Somebody
are.
keeps the combination. Yeah.
With my clients, I send them home with their estate planning portfolio, the hard copies, the signed hard copies. I also send them, however, a bookmarked PDF of their plans, so they have that kind of for reference. And I know a lot of my clients will send it to their successor trustees, or their kids. Some want everything shared.
Mm-hmm.
And
if you're a family that's got dementia in it, you're going to need to make sure that if you are the person who's made this plan and you're in the early stages of dementia, you put it somewhere where somebody knows where it is, because folks with dementia tend to move things around. And so somebody else needs a copy of it, even if it is a privacy issue for you. It's not going to do you any good if it's not someplace where it can be found.
I may be preaching to the choir with this particular group, but also that dementia diagnosis doesn't mean that you are foreclosed from doing any planning at that moment.
Right.
As we know, people have good days and bad days, and as long as I can catch you on early on enough, and it's a good day, and then we can get some of those documents in place, and so I need to know that too, and not just say, okay, we're gonna we'll see in a few weeks. If somebody's concerned that, hey, mom's good days are fewer and fewer, it could be too late to do any planning, but don't just think it's not worth.
Do your best and try. Right.
Yeah.
Right. My mom, actually, I found her will in the closet hanging on a hanger. I knew where it was before, and it wasn't anywhere where it should have been. But when I talked to my sisters about it later, they're like, well, that kind of makes sense. That's where she tended to hide things. So yeah, the closet was where it went. Thank God I found it in time. But
wow.
yeah, you just never know. So we want to make sure that if folks are taking the time to do this, that people can find it. You've had lots of comments saying, thank you so much. This is really helpful. And Steve said, also make sure that if someone is a veteran, that if their deceased loved one is a veteran, that whether or not you're entitled to those benefits. Don't let those go. Do your best to secure them for yourself. We know he went through a long process with that.
The VA can be so difficult to work with.
Yes. Maureen is in Riverside, California, for those of you who are Californians, and she has her own practice, and it's actually really near my office. And if you are looking for an estate planning attorney in Riverside or in California, she's available. If you are in other states, make sure you ask someone that you trust who's gone through the process, or that you check, what do you think, with the Bar Association for people with good recs, or how would they do that, Maureen?
Those are some good options. You're welcome to reach out to me and ask me if I know of anyone in your jurisdiction that I could refer.
Excellent. And we've got Maureen's information in our show notes and on the page, and I'll post them again later today. We hope everyone has a good weekend. For those who are celebrating, a happy Easter. For those getting ready, an excellent time getting ready for Passover and getting rid of all of the leavening. Eat up. And we will see you. I will see you next week, because Deb's going to be in Italy.
Oh, tough.
And I'm being left behind.
But you know what? This show today said, oh, we should take out, in case something happens, we should take out from the firebox and make sure the people that need, in case something happens to us both or one, they should have the copies of the papers. There
Absolutely.
You go. Thank you. Thanks for a good reminder.
Part of traveling, making sure that somebody knows what to do if you don't come home.
That's right.
That part. Yes. So we're doing when we go to Mexico in a few weeks. All right. Bye, everybody. Thank you, Maureen, very much for being here.
Very welcome.
Thank you, Maureen.